Professor Teitel. So I'm happy to return to my seat and allow all that to occur.
Thank you, Professor Bonfield, and I want to welcome everyone to New York Law School this evening. We're really lucky to have Professor Bonfield lead our very dynamic Center for International Law, and we deeply value his remarkable record of scholarship here at the law school as well. It gives me great pleasure to welcome all of you and to introduce one of the most esteemed members of our faculty, Professor Ruti Teitel, for her CV Star lecture on Judging and Judgment in the 21st Century, the International Criminal Court, and the Challenge from Africa's Leaders. The New York Law School has long fostered intellectual exploration in subjects of domestic and international policy, and as an institution known as New York's Law School, we take great pride in casting our glance to issues on law and policy that reflect New York's status as the world's most international city. To that end, the CV Star series has become a distinguished forum for renowned figures in international law to come and interact with the city's legal community. As many of you know, Professor Teitel is the director of the Institute for Global Law, Justice, and Policy, and she is the Ernst C.Stiefel Professor of Comparative Law at New York Law School. I would also now like to take a moment and acknowledge the superb legacy of the late Dr. Ernst C.Stiefel, and it is only fitting that Professor Teitel has the honor of holding his professorship. Dr. Stiefel survived Nazi Germany and came to the U.S., where he eventually became a preeminent lawyer in New York City and internationally. He escaped from Germany after being purged from the legal system, but during the post-war years, he returned to advise the new government on establishing a system of restitution. In keeping with his incredible legacy, the New York Law School community is pleased to have Professor Teitel and her incredible body of work, including her third book published in 2011, Humanities Law, which was also recently published in paperback. And here is a copy of it. We're very proud of it. It's a wonderful piece. Available online. It has received wide-ranging high praise from foreign policy theorists to international law journals. Renowned international affairs scholar G. Ron Eikenberry, reviewing Professor Teitel's book in Foreign Affairs, wrote that it was, quote, an indispensable guide and one of the best explanations yet of the complex, shifting normative foundations of international law. This work and Ruti's innumerable other contributions put her at the forefront of the scholarship on the transformation of international law as it focuses on protecting people rather than states. She's a shining example of New York Law School being the home for preeminent scholars representing New York's diverse location, and her colleagues reflect all of the industries that make New York City their home and employ our graduates. So without further ado, I introduce you to Professor Teitel.
Thanks so much. Thanks so much, Dean Crowell, for that wonderful introduction, and thanks very much, Lloyd Bonfield and the Center for International Law for giving me this opportunity. The CV Star Foundation has given us great support for this lecture series, and it was an opportunity I could not resist to be able to join in that series when Lloyd asked me to. It's a great opportunity to reconnect with alums, and I want to welcome alums that I see around these tables. Welcome. I look forward to catching up with you after the talk, and another opportunity to connect with lawyers in New York who are experts in this area, as well as current students. So it's great to see you all, and last but not least, my colleagues. So I wanted to really work through this topic with you. It's a challenge today, the ICC challenge from a number of Africa's leaders. In recent articles, we have seen the ICC being called a quote-unquote neo-colonial tool that is meant to target only Africans. As President Kenyatta put it in a recent speech at the AU summit, the ICC has been reduced to a farcical pantomime. It has become the toy of declining imperial powers. It has been accused of politicizing justice, of following the cues of European and American governments, and most recently, President Museveni of Uganda, who had been the first leader to refer a case to the ICC, talked about it as a new way for arrogant actors who want to install leaders of their choice in Africa. And it goes on. The AU, African Union, that has celebrated its 50th year, called The Hague racist and accused its processes of race hunting. On the other hand, the ICC has been challenging Kenya and other countries for failure to cooperate in a number of recent cases. So what's going on here? I wanted to work through this issue. Most recently, in the fall, the AU threatened to withdraw en masse. This has been temporarily postponed when UN Secretary General Ban Ki-moon asked them not to do so. So this is the standoff that is the background for this talk. And a little bit of history might help in being able to understand the current context. The International Criminal Court, and this is maybe old news for those of you in international criminal law, but it really is a remarkable development. It's over a decade old. It's the first independent international criminal court that prosecutes individuals, holds them accountable. It was an outgrowth of two exceptional post-Cold War tribunals, the Balkans Tribunal, what's known as the ad hocs, the International Criminal Tribunal for the former Yugoslavia, as well as the Tribunal for Rwanda. And these were exceptional because they were convened either during conflict or immediately after the genocide in Rwanda. But they were also challenged and criticized for being political for that same reason. They were said to be selective, that the UN was picking its conflicts, and criticized for being ad hoc. Hence the demand for a permanent court, for regularity, for rule of law. And with significant civil society support, the Coalition for the International Criminal Court, the various human rights groups, Human Rights Watch, Human Rights First, and others, General Assembly support, the International Criminal Court came into existence, as I said, shortly, a little more than a decade in 2002. So and what about the original players? And Africa was a very significant block of countries, 34 states in the continent of Africa out of 122 state parties supported the Rome Statute and are signatories of that statute. So early on, the ICC, you can say that the African countries, the significant number of them, were part of the basis of support of the International Criminal Court, and they were active players in the negotiations that led to the treaty. There was agreement on individual accountability for genocide, war crimes, crimes against humanity, and aggression was postponed for a later day. The ICC continues to attract support from that part of the world. Most recently, with the wave of Middle Eastern transitions, Egypt has indicated interest in joining the court. And support may continue to grow. There's also no issue of bias in the representation of staff on the court. Many of you may know the former deputy prosecutor has become the chief prosecutor, and it's Ms. Fatou Bensouda from Gambia. The former chief hailed from my country of origin, Argentina, Luis Moreno Ocampo. There are many Africans that hold key positions in the court, including judges and other staff. About a fourth of the permanent ICC staff are African nationals. Nevertheless, and we're coming to the difficult part, when it comes to the docket, out of 8 active formal investigations that the ICC has opened in its 10 years of existence, all of them have been on the African continent. And it would be easy, just armed with that information, to conclude that the court and its prosecutors have in some exceptional way focused on Africa. But here it's important to disaggregate a bit. Contrary to common perception, most of those ICC interventions in Africa were in fact called for and supported by African states. In 5 examples, Democratic Republic of Congo, Uganda, the Central African Republic, and Mali, the situations were referred by the ICC prosecutor to the ICC prosecutor by those very states. And then another 2, Libya and most recently Sudan, were initiated by the United Nations Security Council. And those, I'll say something about those in a minute. The most controversial, however, relates to the most recent, and that is the International Criminal Court's intervention in Kenya, regarding violence following the election of President Uhuru Kenyatta. It is the only case initiated by the prosecutor's office, and in this case, there has been postponement after postponement, pressure regarding witnesses, and most recently a letter from the African Union challenging the substantive jurisdiction of the International Criminal Court in this case and threatening mass withdrawal by the AU. Now, what's clear from this story, from this account, this chronological account, is that, the dimension, what explains the waning support for the ICC in Africa is the nature of ICC jurisdiction. Unquestionably, states were much more supportive when they were the ones referring cases, and most clearly when the cases did not involve state leaders, but rather political opposition. Hence, at the start of the International Criminal Court, Uganda's President Museveni had sought judicial intervention with respect to prosecution of the Lord's rebel army. Similarly, Congo turned to the ICC to take care of the problem of warlords that are now being prosecuted for crimes against humanity. Congo President Kabila had turned over a number of militia leaders, and there's been a conviction of Thomas Lubango Diillo, and there was cooperation. These cases were clear examples, I would submit, of the operation of the International Criminal Court's quote-unquote complementarity jurisdiction. And you can find this in your materials that Michael Rhee put together, and I failed to thank him at the start. I'll thank him again at the end, who's the assistant to the center. And in the materials, you'll find the Rome Statute, and complementarity is mentioned in a number of places, but it's mentioned clearly in the preamble of the statute, as well as Article 17. And what does it mean? It's not a complement. It's agreement on a norm that says that in the first instance, the commitment to the norm belongs to the states that are signatories. And it's only where states fail to act, either because they're unwilling or unable, that the International Criminal Court should step in. And this is a very different setup than with the ad hoc tribunals, where it was really dominance by the international tribunals. There was primacy jurisdiction, where the court, the international tribunals were thought to be, really superior. Here, the normative commitment is in the first instance by the signatory state. And we saw that in the first years of the International Criminal Court, there was a tremendous amount of cooperation. Now, much more contested was the next stage, which was Security Council involvement. And we could see that here, there are those that saw the court as beginning to lose its clear independence. In fact, there were suggestions that the Sudan and Libyan situations had been the most debatable because of the subjects of the court's arrest warrants and the manner of their referrals. And indeed, as you know, countries outside of Africa, such as Russia and others, were, essentially accused the Security Council of mission creep once the military campaign in Libya ended up resulting in regime change. But in any event, that meant that the Gaddafi regime, there weren't sitting leaders that were going to be prosecuted. They were no longer in power. Indeed, the story that's emerging is that the court could be used effectively when it was not referring state actors, but that this thinking shifted dramatically when the court challenged political leaders that were standing political leaders. And this is the confrontation that is now on the table. So now in the confrontation over indictments in Kenya, we can see that there is a very direct challenge to the ICC, and a challenge by the ICC to standing political leaders, President Kenyatta and his deputy Ruto. They were senior representatives of opposing political parties, but regrettably they've bonded with respect to the ICC. So now, and both of them have been accused of orchestrating post-election violence 6 years ago, leaving more than 1,000 people dead. They've both been charged with crimes against humanity. Unfortunately, at this point, in the short run, and this is not how justice is supposed to work, they've been able to, as I said, run against the ICC, securing their victory by a very small margin, but they've dedicated their efforts since then not to cooperating with the prosecutions, but rather to engage in postponement after postponement and to pressure witnesses and other examples of failure to cooperate. indeed an example, and I think it's a very clear illustration of what's happened with respect to the court, given this absence of cooperation, is that after the withdrawal of 2 key witnesses, the chief prosecutor, Fatou Bensouda, had to request adjournment of the Kenyatta trial, and there have already been 2 adjournments of the trial of Ruto. There are many, many illustrations and problems of cooperation. There are allegations about the way witnesses have been treated, allegations of obstruction of justice. We don't have time to get into all of these, but there have been, and on the other side, there are also allegations that the U.S. ambassador to Kenya has tried to bribe witnesses. There are all kinds of claims being made about the problems of securing witnesses for these trials. Ultimately, it's very clear that in cases involving what is known as proprio motu jurisdiction, which is the kind of jurisdiction that was being used in this case, where it was really up to the office of the prosecutor to, he's the one who initiated this indictment, that there is a different kind of problem involving a standing leader. So let me give you a short excerpt of the African Union letter to the president of the tribunal challenging the ICC's jurisdiction. And they essentially have written a letter and given a timetable of April saying that there are no principles guiding the prosecutor in the exercise of her discretion, that there's an absence of transparency and criteria in the exercise of this particular jurisdiction that I've been talking about, which is not when states refer cases to the court and not when the Security Council is referring a case to the International Criminal Court, but when the prosecutor is acting alone without the help and support of the state or the Security Council. And the concern here is the specific nature of jurisdiction, that when the prosecutor acting alone, and the letter ends requesting more transparency and the development of a plan to remedy some of these problems that the AU is calling to the ICC's attention, and threatening that by the end of April there will be no further cooperation. Not that there's been much cooperation with respect to these cases involving the president and his deputy. Now, it's clear that this challenge is of a different order. If you think back to the origins of the International Criminal Court, there had been tremendous support in Africa of that court, along with Europe and parts of Latin America. They have gotten, really a huge number of countries together to oppose the court. There have been ups and downs over this last year, even though there had been a showdown in October. That didn't happen. There wasn't a withdrawal. There's been time, given these postponements, possibly to think about how to reconcile these two, actors. Is there a kind of a binary or an unshakable, difference? Recent events suggest that this kind of prosecution, with the Office of the Prosecutor acting without support of the Security Council and without the support of the state, suggests a different kind of pressure and a different problem. And that's something I'd like to just devote some time to in the remainder of my remarks. One might say that when there's an indictment of a standing leader, that the usual International Criminal Court protection of quote-unquote complementarity will not work. One wouldn't expect a standing leader to cooperate or to turn himself or herself to the court. This lack of cooperation can result in the end of a case, and these are very high stakes, both for Kenya and for the ICC. Very clearly, the risks for the ICC of acquittal due to lack of evidence would only support the argument that it was targeting. If it's dropped beforehand, it would suggest that the court is vulnerable to intimidation, so the court is kind of stuck there. Then the question that the ambassador from Kenya to the UN raised in an earlier meeting, which I was a participant in the International Peace Institute in October, is whether, one can imagine putting the genie back into the bottle. The genie of accountability, of individual accountability? I don't think so. That normativity of the Rome system has been supported by a huge number of states, and in fact, in most cases, this commitment is being implemented at home. Most instances of justice are local. And then the question becomes whether there are any alternatives to this current confrontation between Kenya and the ICC. So here it's important, I think, to recall, in beginning to think through this problem, that the state, and it includes Kenya, is still very interested, at least in its assertions, in its public declarations, in supporting ICC normativity. As mentioned, Africa, along with Europe, was the continent most supportive of the International Criminal Court. The U.S. and Russia and China are still not signatories. And so, and there are statements even as recently as this January where President Kenyatta emphasized that the fight against impunity is a fundamental principle in the basic law of the AU and is part of shared values. And there are a number of other places where he has asserted a commitment to fighting impunity. So are the choices as dramatic as, quote unquote, anti-impunity versus local peace? Is that a productive way to think through the problem? Is the issue anti-impunity, or is the issue remaining that we're working through the problem of accountability against the background of immunity for standing leaders under international law? And to what extent does the creation of the International Criminal Court affect that long-standing customary law in international law? Now, I want to take a minute to talk about this because even the way Kenya poses the problem, they don't pose it as an issue of immunity. Indeed, Kenya limits immunity under its own laws, okay, and as I mentioned, is supportive of the normativity, the anti-impunity normativity of the Rome Statute. Certainly given the provisions of withdrawal in the ICC, there would be no effect on the current case and no effect on Kenya's duties at the moment. It would continue to have to cooperate with respect to current cases that are pending, even if there was withdrawal. So what are we talking about in terms of the effects of withdrawal and what is really at the heart of the problem? I would say that international law today, and in particular international criminal law, is in a very delicate spot with respect to the judgment of standing leaders. There are a few precedents. These are cases of first impression. And even the ambassador to the states parties, Tina Intelman, conceded the ICC itself is a new institution. It's been around for about a decade. It's still working these issues through. When this question came up before a much more senior institution, the International Court of Justice, in the quote-unquote arrest warrants case involving Congo versus Belgium, in an assertion of universality jurisdiction against a public official, the International Court of Justice, often described as the World Court, declared that, quote-unquote, immunity does not mean impunity. That is, that even if for a limited period of time there may be immunity for standing leaders from prosecution in national courts, and to be sure, at that time the court left open the question of how international criminal courts would address the issue, since that was not the case before the World Court. Nevertheless, the court was articulating what is the standard default rule in international customary law, that immunity does not mean impunity, but that there is immunity for standing leaders. Now, that can change when they step down, and there are a number of illustrations. So how does the ICC change then, and what is the direction going forward? Certainly, given custom and the longstanding tradition of international law, we might want to raise the question of how the ICC can implement its goals, not with respect to immunity, but its anti-impunity goal, in a way that's reconcilable with longstanding norms in international law. Now, we know that there are broader purposes of international criminal justice. And in an earlier panel as I mentioned, at the International Peace Institute, the ambassador, president of Assembly of States Parties, Intelman, raised them: peacemaking, stability. The values of the court are stated in their preamble. It is not criminal law for its own sake, but rather to promote other goals, primarily peacemaking and stability. The ambassador from Kenya also raised these, and more importantly, the goal of prevention. And so ultimately, the implementation of norms of the Rome Statute might well have to take into account these broader purposes in its attempt to implement in light of the statutory norm of complementarity. Now, these questions have come up before. In the case of Bashir in the Darfur region of Sudan, and the question of what effect there might be of prosecuting a standing leader, what effects this might have for peace negotiations and politics on the ground. These are serious questions. There are people doing empirical work in political science, political theory, trying to figure out what is the best timing for prosecutions and what effect do prosecutions have on peace negotiations on the ground. Now, these considerations are in one way or another reflected in the Rome Statute. Nevertheless, the Rome Statute in Article 27 states a general rule of anti-immunity, but the default understanding when states sign on to the ICC statute is that they are signing on first and foremost with respect to their duty to prosecute and endorsing the normativity of the Rome Statute, and they're being bound by complementarity. So I think it's extremely important to distinguish the issue and put aside, disaggregate the issue of immunity and the current law on immunity with respect to incumbent leaders and the anti-impunity norm, which is still evolving and is in a state of development in international law, both with respect to domestic courts, ad hoc tribunals, and international tribunals. Indeed, in the International Court of Justice, in the recent Germany v. Italy case involving a lawsuit for post-war reparations, the International Court held that the normativity of the ICC and its anti-immunity hadn't changed current customary law, and that there was no change due to the ICC state practice or opinio juris. Now, if this is not taken into account, I think we're really talking about nothing short of regime change through the courts. And this is something that has to be confronted by the international community in its understanding and interpretation of the Rome Statute, and it also needs to be wrestled with by the Assembly of State Parties. One might call for balancing the interest in anti-impunity with other interests such as peace and stability, perhaps calling for prudence in the exercise of the discretion of the prosecutor. It would be a matter of regret if there is outright politicization of the ICC and of the Rome Statute. Rome is a normative system, and it would be a matter of great regret if after so much effort that's been put into the institution and also this similar normativity in other areas of international law, if there is politicization of the ICC in either direction. After all, the African Union, the region of Africa, was one of the first promoters of the ICC. It was signed on to immediately, and there was support for implementation in Kenya after the 2007 era of violence. Now, perhaps there was an element that was political as well about that, and there were certainly external elements, but it would be a matter of regret if the reason being given now is a short-run political reason as opposed to the broader normative understanding that this was something that was supported in Africa because of the concern for peace and stability, concern for international conflict in the region. And it would send a lamentable message. Now, I hear ICC advocates saying the reverse and concerned that there would be a lack of adherence to the norms. Rather, I think this is a question of implementation. And if the issue is implementation and not the normative question, then what we're talking about here is that there needs to be a very serious engagement with the complementarity provisions, with the invincibility rules of the International Criminal Court, in order to avoid confrontation by taking into consideration some of the issues we've been talking about in areas where the ICC is relativizing existing international law, and in particular international customary law. We've mentioned the infancy of the court. Some of this has already been reflected. Some of the concern where the court has tried, has gone back and forth in a kind of yo-yo of giving some accommodations to Kenya's president. First, the trial chamber said that President Kenyatta might be excused from continuous presence at the trial, but then this was overturned. And there have been similar requests in the Ruto case. Now it seems that absence from trial, even for standing leaders, will only be permissible under exceptional circumstances. I want to conclude by recalling that the ICC, like any international statute, needs to be read in light of its own object and purpose, which is one of the essential principles of the treaty interpretation, and its broader purposes of maintaining peace, securing accountability, and preventing future crime. Hence, and it's important to recall that what the ICC has achieved so far is an important dialogue on the topic of global criminal justice, about complementarity, and about the importance of local justice. In this regard, this court has clearly transcended the ad hocs, which had insisted on the primacy of international law and ended up alienating key constituencies, including victims. Now the International Criminal Court has contributed to a widely shared understanding of the idea of accountability, and in particular the view that individuals are responsible for these very serious crimes, and in ideal circumstances that defendants should be prosecuted. Indeed, this goal has been supported by the African countries that I've been discussing. But the ICC is not an island and cannot operate like one. The goal is not absolute. It is not the only goal in international law and international affairs. It involves and is subject to other criteria, degrees of consensus, dialogue with local institutions, and decisions in particular made solely by the prosecutor under proprio motu jurisdiction need to be transparent, and the criteria need to include the factors that I've listed. And some of them may well echo some part of the AU request. Maybe in the Q&A we'll have a chance to talk more about how the ICC can take into account the existing transitional context in Kenya in its interpretation of admissibility and complementarity. One might conclude with the proposal that where an official is democratically elected and is not currently engaged in serious war crimes or related human rights abuses, nor is likely at the time to engage in such crimes, that prudence could be exercised, militating for postponing, and that the right time to engage in prosecution would be after the official has left office. This proposal would allow the possibility of postponement by the UN General Assembly where there are sitting leaders subject to prosecution. There is a need for a stronger complementarity agenda and substantive engagement with Africa's leaders and leaders elsewhere, civil society, and victims if the court is to be successful and effective in administering justice in Africa and elsewhere. There are important rule of law values at stake that hang in the balance. Thanks very much. I look forward to your questions.
Thanks very much for Ruti for a very provocative and informative lecture. I'm sure there'll be lots of questions to hold you up for the next 25 minutes. I'm just going to point to people because my eyesight is not that good. And if you could just rise and just state your name so that everyone else knows who you are.
Thank you, Professor Teitel. I'm Elise Capella,
Sure.
Associate Director of the International Justice Program at Human Rights Watch. In fairness, some might say I'm in the ICC advocate camp. In the interest of full disclosure, but I was hoping to just take a minute to kind of challenge this issue that anti-impunity can be reconciled with immunity for sitting officials. And of course, you rightly point to the issue that in state practice, immunity before courts, even when officials are implicated in serious crimes, has in fact been the case from time to time, varying from situations. But what we have not seen is that immunity for state officials before international courts. And that's been true since Nuremberg. So it's not a new phenomenon, but in fact something that has charted the very progress of international courts set up to prosecute serious crimes. Because I'm thinking here of Nuremberg, I'm thinking of the Yugoslav Tribunal, the Rwanda Tribunal, the Special Court for Sierra Leone. And in fact, I think what we can say is that the whole creation of international criminal courts has been about the reality that serious crimes can not only be prosecuted or sometimes serious crimes cannot be prosecuted before national courts because of inability or unwillingness. That's why you need international courts and a commitment to not allow official position to bar prosecution before those courts. In addition, on Eurodia, it explicitly accepted jurisdiction before international courts when it held that immunity was appropriate in that instance. So I think there is a real question as to whether or not there's customary practice at the international level. And in fact, the trend and status has been to bar that immunity at the international level. I think it's also important to flag that Kenya was given ample opportunity in the lead up to the ICC prosecutor opening the investigation in Kenya to handle it domestically. In fact, there was a widespread feeling that Kenya was the kind of place where there was an established enough national system to take on these cases. For months, I think more than a couple of years actually, stalling, avoiding, not dealing with the cases. That's what led to the ICC prosecutor opening up this situation. It's also important to note that the suspects who were elected president and deputy president in Kenya ran on a campaign that they would cooperate arguing the opposite. A final point is that I work with civil society across Africa on these issues. And what we've seen is that while the official rhetoric at the highest levels in the AU, which unfortunately is easily manipulated by a small minority of African leaders seeking to undermine accountability, that's the rhetoric you hear. What's often left out of the debate is the voices of civil society on this issue. And I see from Dakar to Johannesburg to Accra to Freetown to Nairobi, very much in Nairobi, strong feeling that African leaders need to stand up for justice and the ICC, not compromise it. It's not perfect, but it needs to be improved, and that should be the focus, not seeking to roll back the idea of justice for the worst crimes, irrespective of professional position.
Yeah, well, your account of history, I mean, particularly Nuremberg, I mean, the Reich, they were not standing leaders at the time. Every example that you talk about are cases where there had already been a military victory, and so then they were put on trial. In fact, it's quite, it's the custom over the ages has always been that leaders take their own lives and they refuse to, surrender. It's not, I would hate to make that the case, the test case for justice, right? This question of the standing leader. And the International Court of Justice spoke and said, that's the most recent is the Germany v. Italy case about the existing customary law. And I think that, sometimes the International Criminal Court has to recognize that they are operating against a tableau of existing international law, that they are not the only actor in international law and international affairs. I fully understand and expected your points. And of course, the victims are often given as the reason for prosecution. I'm not convinced that the past is the full reason for prosecution. It's really about the transition and being forward-looking. And generally, the statutes that we're talking about have forward-looking goals. They're not only about the past victims. They're not the articulation is not in retributive terms, nor is it in reparatory for the victims. It's about peace and stability and deterrence going forward, which is a much more traditional value in international criminal law. And I think that what we've seen in the contestation between, Kenyatta, Ruto, and the prosecutor is that the victims are not being well served. They're being intimidated. There's pressure on witnesses from both sides. It's practically impossible to prosecute at this time. So this is not an argument for immunity, forever. It is an argument for limited immunity while those are standing leaders, and it's certainly not an argument against impunity, for impunity. I think that's a misunderstanding. Yeah.
My name is Nalvina. Thank you for your lecture. It's very illuminating. I wanted to ask two questions about your last suggestion. First, you talk about democratically elected leaders, which is fine when you're sitting in the United States, but many nations... Not really,
not always, you read Bush v. Gore, right? Yeah. So, I don't think we can say that this is our projection or something.
But there are many nations in the world that don't elect the nations democratically, and they're still nation members of the UN, et cetera, and I'm not sure, I want, is that why democratically? And adding to that, justice delayed is many times justice denied. And not just in a evidence gets stale, witnesses like we see in Kenya get disappeared. How do you suggest to deal with that if you indeed have a non-sitting or non-sitting heads of state being tried?
Great. Thanks so much, and thanks for coming. So I would say that obviously the question and how one would apply a democracy test is always going to be a continuum. I mean, there will be clear cases where, it's a dictatorship and a dictator writing their own amnesty and writing their own immunity without other support. And that would be the clearest case, right, of not, where the court would not be deferential in those cases. And, we're talking, this is an area that is not just a matter of law, it's law and politics, right, on the ground. And as far as the justice delayed is justice denied, actually what we see with respect to this particular area where states are involved in criminality is that there's a paradox of the passage of time, and that often it's after decades that prosecutions occur, particularly at the national level. So Argentina today, 3 decades after the facts of the dirty war, is having prosecutions, right? That where there was fear, where there were compromised judiciary, now it's not compromised, now it's a new judiciary, the military, there's a new generation, there's an alacrity with which people are running to prosecute, and, you could say, well, there are political reasons there as well, but, the same thing was true in Germany. You didn't have trials at the beginning. The trials policy for post-World War II Germany was started in the 50s and then has continued, and the same has been true about collaborator trials in Europe. So I don't see the passage of time, and particularly most terms are 5, 10 years. I don't see this as a huge amount of time. I think that, if anything, it's protective of the, of witnesses and of victims. It assures that there will be, that the institutions will be less compromised. There'll be less fear. I see it as actually it's a paradox. When the state is involved in crime, there's less of an argument for speedy trial because the state controls the evidence and usually is able to engage in denials and cover up and lack of accountability. So we see that it's really, you get more justice with the passage of time.
Thank you. My name is Nora. Thank you, Ruti. Always very intriguing to hear your thoughts. Now, going back to Africa and African Union, do you think it's a real threat that the AU or the AU countries would be withdrawing from the ICC system? And would there be maybe a way to alleviate the tension from the inside? We have the ASB coming up in New York later on this year, and there will be a new president for the Assembly of the State Parties being elected or chosen. Now, it's quite likely that the new president might be from African countries, so that would create, I believe, quite a new dynamic within the institution.
Well, I think that, thank you for coming and for your thoughts. That sounds like a promising development. I think, given your work on international criminal law at the UN, that you're probably in a better position than I am to assess the politics. But I think it was averted, and in the fall, this is really an issue of politics and not of law. The question of whether there, what is likely or not likely. But certainly, having some personnel change could be a factor that might be promising. I think the idea of having transparency and clear criteria for initiation of prosecutions when it's the prosecutor acting alone, I think this is a very important recommendation on the part of the AU, and clearly the International Criminal Court is in its early days. It would seem to make sense to be as transparent as possible. Also about the nature of other investigations. If more were known about investigations that were occurring with respect to countries outside of Africa, then there wouldn't be the perception of this kind of targeting. I think the more transparency and the more clear criteria that the ICC displays, and this is certainly something that they can work out in dialogue with the Assembly of States parties, the better. And we have the beginnings of some of these factors that have, I think, sort of come to the foray over the last decade. Yeah.
I think there was a question over there. Yes.
Thanks. My name is Kristen Rocco from Jacob West and the City University of Wisconsin. Thank you very much for the presentation. I probably follow this issue less closely than many people in the room, but your presentation raised two questions for me. One was on just the scope of the AU's challenge to the ICC. And if my memory of this is not particularly clear, but I thought that this fall there was a communique from the African Union, not just a letter to the court, but that in that communique it raised more broadly the objection to investigation of any sitting official or sitting head of state, at least, full stop, not just on the basis of democratic election or otherwise. And I found that particularly troubling, not because of the Kenyan example, which I agree is one of those ones that's more on the margins because it's a democratic state, but because of the Sudan example, because of Bashir. And so the question it raises for me is, how would your proposal play out in terms of enhancing the court's legitimacy? Because it would still create a situation where sitting heads of state could be referred by the Security Council, for example, like Bashir, and then also, I know there's going to be a push coming up for North Korea to be referred. Now, there's been this Commission of Inquiry report published by the UN this week, and that's one of the recommendations, even if China vetoes it. But if you've got the Security Council still acting in that sense, does it not, it eliminates one aspect of jurisdiction that's potentially more independent and more legitimate seeming, which would be the prosecutor, which isn't, directly controlled by governments. So how would that play out in terms of the overall posture of cases before the court?
Yeah, so a great question, and I want to thank the Jacob Blaustein Institute. Several of our students have interned there, and you're doing great work. Same is true of Human Rights First and Human Rights Watch. The proposal I gave is not the proposal of the African Union. I have, this was my own proposal, and I certainly didn't represent every aspect to the original communique. There's been a call for amendments to the International Criminal Court statute to deal with the issue of standing leaders, and also to allow for postponements. That wasn't, I'm not making the kind of expansive, that kind of expansive critique that you mentioned in the first part of your question. But I think that the Sudan example and North Korea perfectly well illustrate the usefulness of the proposal, because both with respect to Sudan and with respect to North Korea, you would be talking about non-democratic leaders that are continuing to engage in human rights abuses. Nevertheless, the proposal is broader than that, which is that you really need to have on the list prudence, which is balancing the factors of anti-impunity with some of the other goals that the International Criminal Court is devoted to. And, frankly, when you raise North Korea, I followed the issues in North Korea fairly closely, because there is a question about the likely transition there, and, hopefully someday, right? I think one would want a very serious, exchange about whether an indictment of the leaders in North Korea would be a useful step in limiting the power of that government. I think there are a lot of issues. Nuclear issues are just one of them, but it's not trivial, right? It's not just a matter of, is there evidence, right? Yes, the report gives us evidence. People who have been following the issue, who have listened to the survivors, like Shin, one of the few escapees of Camp 14, know how terrible what's going on in North Korea is. And there's torture, there's extermination, there's mass starvation, along the lines of a totalitarian state. And I know that's, we've had some of these discussions with former students, and it may not be convenient for some to recognize that, that's going on. But the question of what the international community does should not be left for, the prosecutor's office single-handedly. I think that we need to have a more robust exchange about some of these competing goals. And again, it's not about immunity in some kind of, immunity forever. We're talking about a very limited immunity and for a period of time. And again, in any event, North Korea is not the same as Kenya in terms of the existence of ongoing human rights violations of the most serious sort happening at the time. Yeah.
My name is Kevin McMullen. I'm sympathetic to the AU's position, disenchantment with the court. And if I were them, I would withdraw, at least for the moment. I'm sure they didn't have in mind when they supported the treaty that they'd have a situation where permanent members of the Security Council are not members of the treaty. And one of them even has had its Congress say that the President is authorized to take military action to rescue any American who goes before the court. And while at the same time claiming the right to indict leaders from other countries that are not parties to the treaty. This is humiliating for the other countries involved. The least that I would recommend, if I were them, as changes in the treaty would be that if you're a member of the Security Council, either permanent or temporary, and you're not a member of the treaty, you don't get to vote. And you don't get to vote in the Security Council to apply this treaty to any country that's not a member. And that we need some kind of procedure for a subsequent regime in a state to decide that it's better to allow a leader to go into exile, to escape punishment, in order to regain democracy and do away with the Civil War. A few years ago, you remember at the International Law Weekend, it was kind of an anti-Pinochet pep rally. But one of the speakers got up and said, if the people of Chile think it's worthwhile, in order to regain their democracy, to allow Pinochet to escape, they should make that decision, and we should respect it. Now, later on, as years go by, they may withdraw his immunity and prosecute him and other people. But that's something that should be decided in Chile. Like Idi Amin was allowed to go into exile. Napoleon was allowed to go into exile. That's something that the community there should decide. I saw a few years ago a woman in Northern Ireland whose son, a policeman, had been killed by an IRA member who was now getting early release from prison as part of the peace plan. That was just an angry woman. But sometimes choices like that are the price you pay for peace and reconciliation.
Well, so anyway, on your amendment regarding the Security Council, that'll become known as McMullen's amendment. So I will leave that one for you. But I think that the broader point you make is that there used to be this political space, both with respect to Chile, with respect to South Africa. The Truth and Reconciliation Commission, on condition of full disclosure with respect to crimes that were part of the apartheid policy, gave amnesties on a case-by-case basis. And that political space existed, and it was important for South Africa in order to be able to move on. It was not something that all victims favored, and there were victims that sued with respect to that policy. There had been a commitment in the Constitution. There had been a consensus in the country, and really a very significant consensus reflected in their transitional constitution. And you raised Northern Ireland. That, too, is an area that I follow closely. I'm involved with the University of Ulster Transitional Justice Institute, and these have been part of the human history, right? These instances where difficult decisions were made to either limit prosecutions or to postpone them for another day in order to be able to guarantee peace and stability. So I think, you know, this is part of what I raised in the talk, which is that we really are in a new terrain, right? With the International Criminal Court, which didn't exist at that time, and it didn't, wasn't able to limit the choices that were made in Northern Ireland. It wasn't limiting the choices in Argentina. The first speech that the Argentine prosecutor made was, "This is not Nuremberg. We're making our own decisions." So they initiated a prosecution policy, and then for a variety of reasons there was resistance among the military and some other institutions, and they had to postpone it. So Pinochet is more complicated because, often there are global actors, there are victims that went to to Spain, and then the issue got reopened. So it's not about, a consensus that remains static. Often there are consensus at a transitional time, they get reopened later, and a variety of different values that need to be reconciled. I don't know if there are other questions, and if not, we could adjourn for a more informal, if people like. I'm happy to keep going. Yeah.
Question? Sir.
Yeah, I just have a question that concerns the very, I think compelling and imaginative argument that the exercise of prosecutorial discretion should take into account the broader universe of customary international law and where it stands. And so obviously there's no dispute that the statute is a lex specialis with respect to the issue of immunity. So in a sense, if one regarded the prosecutor's office is basically simply responsible to the parties, to the treaty, and the ICC regime is a self-contained regime, then it would be questionable whether it would be really relevant that we look at arrest warrants or Germany v. Italy, that the normative equilibrium between, on the one hand, the traditional concerns underpinning immunity and the accountability consciousness represented by the ICC has shifted so much that, that the idea of prosecution of sitting leaders itself, is kind of an emerging norm of general international law. But that still leaves us with, the relationship of the responsibility of the prosecutor's office to the parties to the treaty who created a lex specialis versus some conception of responsibility to the international community as a whole, or to the international legal system, as a whole. And I was wondering if you could say a word, perhaps based upon your other scholarship, including some of it that was, I think, mentioned in the introduction to the talk, about how one could understand such a broader responsibility, or the ICC as embedded in a broader international legal universe, such that the general equilibrium on this kind of question of international law would still be normatively relevant.
Well, thanks. And obviously, there are places where one could see in the ICC statute and in its implementation that it has to rely on other law. It can't, principles of international criminal law are very, very recent. They're relying on criminal procedure and understandings of criminal law that relate to all kinds of different regions. They cite to different regions. They're not able to operate as an island, right? It's dates from 2002. I think also one might argue that the principle of complementarity, the notion that the court comes later, it's a court of last resort, also assumes that they would be, working within other, systems of internationally and transnationally relating to other courts and other prosecutors' offices. So it's actually a very deeply embedded court, I think, in that regard, and one can see this in some of the of the language. So that, I don't think it's possible to just think about the statute as, in isolation, right, and as a lex specialis, the way one might think about maybe an arbitration or something involving just two parties. I don't think it's possible really to think about the court in that way. Whether this changes and whether the norm, the customary law norm, 20 years from now moves in another direction with respect to standing leaders, perhaps, right? That it might, but I don't see that happening anytime soon, given the International Court of Justice's ruling in Germany v. Italy. And it's interesting because the International Court of Justice has related its rulings to other tribunals, criminal tribunals. So the court doesn't see itself as deciding the question of a civil suit in isolation from the criminal tribunals. It recognizes that there's a place for individual accountability, but it also recognizes temporary immunity. So I don't know if that fully answered the question, but it was an attempt in any event.
So before we give Professor Teitel a well-deserved round of applause, I just want to quickly remind you that there will be 2 more STAR lectures in this semester, one in early March on maritime financing by Mr. Berman, and one on the Foreign Corrupt Practices Act by Thomas Hickey. So now we can give Ruti a well-deserved round of applause.
Thank you for your questions.
There is a reception next door, out this door, and to your right.
Thank you.
Thanks very much for coming.